Okay, hi everybody. Thank you for your accommodation and listening to my presentation via recording. So I'm going to talk about a few cases that stem around the the Indian Arts and Crafts Act that you just learned about from Richard. The first case that I'm going to talk about was required reading. I also did a little bit of outside research, so the last two that I discuss were not required reading, but I hope that it gives you a broader understanding of the Act and how courts interpret it. So the first case, Native American Arts, Inc. v. the Waldron Court, stems around whether or not using tribal names on tags of certain products that say Navajo, Crow, or Southwest tribes, for example, falsely advertise that the products are made by Native Americans. So the facts of the case are as follows. The plaintiff is a seller of American Indian goods that are produced by American Indians. It brought suit against the Waldron Court, who is a manufacturer of non-Indian produced jewelry, for selling it as advertised as Navajo, Crow, Southwest Tribes, and Zuni Bear. The jewelry was accompanied with tags that gave facts about the tribes. The advertisements identify the designer of the jewelry as Trisha Waldron, who is not a Native American. Neither the tags or the advertisements contained any disclaimer about its authenticity. The case went to trial and a jury held for the defendants. The district judge held that the following code of federal regulation was unconstitutional and therefore refused a particular jury instruction. This case is the appeal made by the plaintiffs. So as you already know, the Indian Arts and Crafts Act of 1935 forbids selling a good in a manner that falsely suggests it is an Indian product. 25 Code of Federal Regulations, Section 309.24, details how the statements about Indian origin of art or craft products should be interpreted. Section A2 specifically states that the unqualified use of the term Indian, or of the term Native American, or the unqualified use of the name Indian of an Indian tribe in connection with an art or craft product is interpreted to mean for purposes of this part of the art or craft product is an Indian product. Plaintiff's argument is that the district judge should not have ruled that 25 CFR is unconstitutional, nor should the judge have ruled that the unqualified use regulation infringes freedom of speech, and it's also unconstitutionally vague and overbroad. Regarding this issue, the court held that plaintiffs were correct and the district judge should not have held that 25 CFR is unconstitutional. If he was correct, trademark law would be unconstitutional. Basically, this regulation makes Indian a trademark denoting products made by Indians. It's just like calling a particular cheese Roquefort cheese, which means that it comes from sheep's milk cured in limestone caves in the Roquefort region of France. It would be fine for non-American Indian manufacturer to advertise the similarities of the product, but when using the word Indian, he must explain the usage so consumers aren't confused by who actually made the product. However, the court argues that the real issue is who defines what is an Indian product and what is an unauthorized use. The regulation comes from a small office in the Department of Interior called the Indian Arts and Crafts Board. So in other words, does the regulation actually authorize the Arts and Crafts Board to determine what is an Indian product or what constitutes false advertising? And further, how do we instruct juries and fact finders to determine what is an authorized use? There's no indication that Congress delegated the department authority to determine what constitutes sufficient proof of false advertising. Just because the board could define what an Indian product is, that's not an essential part in proving customer confusion. This is especially true since the consumers at issue here are not Native Americans. The court does go on to say that What if we're wrong and the regulation administers suits to enforce the Indian Arts and Crafts Act? Then the meaning of unqualified use would need to be defined, and that definition would hold heavily on jury instruction, closing arguments, and the jury's verdict. So, what could a definition or meaning be? Maybe using the word or name to denote an Indian product without including a disclaimer, such as Indian style or not manufactured by Indians. Maybe we could look at the dictionary definition of the word. That would be not modified by reservations or restrictions. In this case, the defendant did not include a disclaimer. So if the definitions above are accurate, the plaintiff could have won on summary judgment, but they didn't move for summary judgment, and their lawyer said that although a disclaimer would be the best method of qualifying the use of the term Indian or the name of a tribe, it is not the only one that would satisfy the regulation. Other contextual references could do so as well. So how should the regulation be worked into jury instruction? Plaintiffs think that every statutory provision or regulation applicable to a case should have its own instruction in the language of the statute or regulation, but this could be extremely confusing for the layman. Judges should state those rules and principles in simple, everyday, non-legalistic language. Using the plaintiff's suggestion would have required the jury to return a verdict for them if it simply found that the defendant failed to qualify its use of the names of Indian tribes in its ads and labels, or that it had falsely suggested that its products were Indian products. The court suspected that the jury would have been confused by this regulation, especially when it would have been explained to them that the required qualifications could consist of any pertinent contextual elements, like the picture of Trisha Waldron or the type of store where the jewelry is sold. The only way the regulation would be pertinent in this type of case is if there was zero context. For example, one where a bracelet was sold as a Navajo bracelet with no mention of the manufacturer or even identification of the outlets in which the bracelet was sold, just the bracelet and the price. But there was plenty of context in this case. So the jury needed to answer what the entire sales packaging suggested to the average customer. So this includes the tag, the style, the store, the decor throughout, the location of the store, the advertising, the customer base, the creator, the designer, everything. It's not just what the names of the jewelry had meant. So the court affirmed the prior ruling. Some other similar cases, and like I mentioned earlier, they were found independently. They weren't required reading, but I hope it gives you a little bit more to digest. Are both brought by the Native American Arts Inc. And they're both a little bit different than this holding here, and the courts kind of used the act differently. But in Native American Arts v. Contract Specialties, the plaintiff sued Contract Specialties for violation of the Indian Arts and Crafts Act for advertising, marketing, and selling non-Indian products nationwide in a manner that falsely suggests they are Indian made. They did so, again, just like the previous case, by including tags that were labeled Indian, Apache, Navajo, Kiowa, and Cree without disclaimers or qualifiers. This case was a motion to dismiss by the defendants on a few different grounds. The court denied each of them and allowed the case to go forward. I did not find a further case, so I think it's safe to assume that it settled out of court, but I still found it interesting that the court denied each of the defendants' dismissal motions. So the first was a failure to state a claim of unfair competition. Specifically, the plaintiffs argue that defendants' marketing and sales of its fake Indian-made products allegedly had eaten away at their sales, driving down the price of their products, and damaged their goodwill and reputation. Defendants argued a lack of standing. They said that the plaintiffs can't prove an actual injury in fact because they do not sell their products in the state with which the plaintiff resides, which happened to be Illinois, and that the plaintiffs had no employees, business locations, offices, or property in the state where defendant resides, which was Rhode Island. Interestingly, though, both parties sold their products nationwide. The defendant argued that the statute should be read congruently with the Lanham Act, which requires an inquiry into the parties' area and manner of production, marketing, distribution, and concurrent use to determine that they do, in fact, compete with each other. However, the court did say that this is a motion appropriate for summary judgment, and that the defendants, if they filed for summary judgment, could win on that basis if the plaintiffs failed to bring forth evidence of injury. So they denied that motion to dismiss. Second attempt by the defendants was that there was a First Amendment argument, that this statute violates the First Amendment. The court states that the meaning of Indian product is determined under regulations promulgated by the Secretary of the Interior, which I talked about in the previous case, which defined Indian product as any art or craft product made by an Indian. The regulation further states that the term includes, but is not limited to, art made by an Indian that is in a traditional or non-traditional style or medium. Defendants argued that this means that anyone can be criminally liable for creating anything that is either a traditional or a non-traditional Indian style because it's unclear what that actually means. The court says that they're wrong. Nowhere does it say that anything made in these ways is pretending to be an Indian product, and the statute goes on to say that an Indian product under the Act does not include a product in the style of an Indian art or craft product made by a non-Indian laborer. So they lost on that one too. Finally, the equal protection argument was their last attempt. The defendants argue that the statute is race-conscious statute, and since it grants Native Americans a right not enjoyed by other Americans, it should be subject to strict scrutiny. But both the Supreme Court and federal courts have long held that statutes providing for special treatment of Indians will not be disturbed as long as the special treatment can be tied rationally to the fulfillment of Congress's unique obligation towards the Indians, and that Indian affairs legislation is subject to rational basis review, not strict scrutiny. So that's the end of that case. Next, I bring up Native American Arts Inc. v. Indio Products. This case is about the defendant arguing that the plaintiff lacked standing because they did not prove injury in fact. The court concluded that plaintiff did not prove that they suffered an injury because their arguments were opinions unsupported by evidence. Similar to the previous case that we talked about, that you really need an injury, but this case really focused on the fact that the evidence given to the court was unsupported. Just because defendant and plaintiff offer similar products through similar mediums and markets, it's not enough to show injury. Specifically, defendant primarily sold candles, and far less than 5% of its products had an Indian theme, while the plaintiff exclusively sold authentic Indian products. And similarly to the prior case, the defendant doesn't have any offices or employees, or advertises its products in the plaintiff's principal place of business, nor has plaintiff had offices or employees or advertised its products in the defendant's principal place of business. Plaintiff argues that just because both companies sell some of their products on the internet, the scope is the same. The court holds that it's not willing to hold that two parties are competitors simply because they both sell products on the internet. Did defendants' actions actually violate the Act? Using the Lanham Act, the key inquiry is whether Indio marketed the Indian-style products in a manner likely to cause confusion regarding their origin. Plaintiff argues that 1. Indio is Spanish for Indian, so Indio's name translates into Indian products. 2. Indio's logo is an Indian with a headdress. And 3. Indio labels the products with the terms Indian or Native American. And finally, 4. Indio's Indian-style products are like those commonly made by Indian Americans. The court held that these facts mean the defendant sells products with an Indian motif. They never represented that the products are authentic, real, original, genuine, collectible, or made by an Indian tribe. The court continues to say a reasonable consumer, particularly one searching for authentic Indian products, would not presume that a product is made by an Indian American simply because the business selling the product and the product have an Indian motif. Another really good example, when a customer dines in a Mexican restaurant, they don't automatically assume the food is prepared by Mexicans or that the restaurant is owned by a Mexican. Or when someone purchases a samurai sword, they don't automatically assume it was made by someone of Japanese descent. So I hope that helped you guys get a better understanding of the act and how courts interpret it. And again, I thank you very much for accommodating me and my baby. Have a great day, guys. Bye.